Okay, welcome back to Invention-Con 2020, the second half of day one. Remember that there is programming both Friday and Saturday. If you haven't checked the agenda for those programs, you can do so at USPTO.gov. You can search for Invention-Con, and the agenda will pull up on our Invention-Con landing page. If you have any questions during the program, please remember on the right side of your screen in the description, you will see an email address for Invention-Con at USPTO.gov. Please feel free to email us questions during the presentation. I will be monitoring the mailbox and asking questions of our presenter after the presentation is done. But if you have any questions that come up during the presentation, feel free to email us those presentations and we will get those in front of the presenter. Before the program is over, we will send those questions out to our presenters to help get answers if we don't answer it live today. So please know that we will get to your questions one way or the other. At this time, I'd like to introduce Janice Tippett. Janice will be presenting on best practices for filing a successful patents application. Janice works in the management and program as a management and program analyst in the Office of Patent Application Processing here at USPTO. And at this time, I'll turn it over to Janice. Janice, thank you for presenting today.
Thank you, Sean. Like Sean said, I'm Management and Program Analyst for the Office of Patent Application Management, and it's my job to kind of help our operators know how to apply the rules and process applications consistently and correctly. And so my job today is to help guide you through filing an application, a patent application that, so that you can get through the filing process quickly and without problems. I'm not able to, there we go. Alrighty. And this presentation is going to be, again, how to avoid common application filing issues. So this is going to address some of the things that we see most often, especially with independent inventors, that kind of cause us a bit of a stumbling block to getting through the application process and getting to an examiner for patentability. Okay. So one of the biggest things that we see is that documents are not properly signed. All documents submitted to the Patent and Trademark Office in an application need to be properly signed. And what this means is if you're working with a registered practitioner, the practitioner can sign documents even if you haven't appointed him to have power of attorney. If you're just using him as consultation or whatever, and he signs the documents. If you're not working with a registered practitioner and you don't have an applicant named on an application data sheet, and we'll get to that later, then all inventors must sign each document or submission. And what we find a lot is that one applicant or one inventor will sign for the other applicants or inventors, and but they won't have like the authority to do so. If you are planning to do that and you're not working with a registered practitioner, all the inventors may come together and appoint one of the inventors to prosecute the application on everyone else's behalf. Each inventor must sign the form that is appointing the inventor, and we do have a form on our website, and the form is pictured here, and you would want to fill one of these out for each inventor listed as an inventor. So if you have 4 inventors and you're giving John Brown the power to act on behalf of all of the other inventors, then inventor 1 would need to fill one of these out and sign it. Inventor 2 would need to fill one out and then sign it. Inventor 3 would need to fill one out and sign it. And John Brown also would need to fill one out and sign it to appoint himself. So we need the entire inventive entity to sign that. Okay. Working with a practitioner, if you are working with a practitioner and he can sign just about anything. There are one or two exceptions to what a practitioner can sign on the inventor's behalf. And the office does strongly recommend that you consult with a practitioner just to help guide you through all of the different rules and requirements to get a patent application through. And then if there is an applicant named on the ADS, then a practitioner must sign the submissions on behalf of that applicant. Okay. The signatures must be properly formatted. So in addition to having the right people sign the documents, the signatures also, they can be handwritten or electronic, and certain formatting requirements rule each of those. So if the signature is not properly formatted, the document will be considered to be not signed, and any unsigned documents or submissions will not be entered into the file record. So it's very important to sign properly. Now, an electronic signature is what we call an S signature. And an S signature must consist only of letters, including kanji is the Japanese lettering, Korean lettering, things like that. So it's letters or numbers or both, spaces, commas, periods, apostrophes, or hyphens, but no other punctuation or special characters are permitted in an S signature. So only letters, numbers, spaces, commas, periods, apostrophes, or hyphens. And the person signing must insert his or her own signature, which is the combination of letters and numbers and characters, between single forward slash marks. If you leave off a slash mark, or if you have an extra slash mark, that is incorrect formatting, and it will not be accepted as a proper signature. The name of the person must be printed or typed immediately adjacent to or below the S signature, and be reasonably specific so that this identity can be recognized, so that we can confirm who it is that's signing the document to make sure that they have the appropriate authorization. A registered practitioner may S-sign, but his or her registration number is required as part of the S signature. And you can see the examples below. The signature does not need to include middle initials, but the signature must contain a suffix if there is a suffix for the name of the person signing. So if you have an S signature, the suffix doesn't necessarily need to be in between the slashes, but it does need to be in the identification for the signer. And if the person signing the document is not a registered practitioner, if it's just one of the inventors and you don't have a practitioner number, then the registration number section on any form should be left blank. Any numbers included with the signature will be interpreted as a registration number, and that may invalidate the signature altogether. Okay. A handwritten signature must be original or a copy of an actual signature. If you use a copy of the signature, if you use a copy of the form that was originally signed, then you want to keep the original with the original signature on hand so that you can prove authenticity if need be later on. someone maybe says that there was a forgery or someone signed on your behalf or something without your knowledge, you know, you can authenticate that signature by keeping the original. Okay. And if there is a handwritten signature, there is no requirement for a printed name to accompany that. However, the handwritten signature, if we can read it and it does not appear to identify the signer, then we would also find that unacceptable. Okay. When using any of our web-based forms, additional signatures can be added using the Add button, and there's highlighted down there at the bottom to show where those normally can be found on the web forms. And any other forms, if you use a form that's not a PTO web form, then additional signatures would need to be added by other means, you know, by adding additional lines or something like that. Just so that we have all the information that we need and all of the language is clear and appropriate, the USPTO does strongly recommend the use of our web-based forms. They're designed so that we do have all of the information that we need and so that we can collect that information quickly and efficiently. Okay. When you submit documents to the U.S. Patent and Trademark Office, these are the following, these are the submission methods that you can use. Any of these can be used to send documents to the Patent and Trademark Office. However, a certificate of mailing is not honored for the purposes of a filing date. So you can send your application in the mail, just regular mail, but the filing date will be whenever we get it in our hands. If you submit an application using the Priority Mail Express service, then we consider the application to have been received when it is received in the post office. So if there's any kind of delay or anything like that, you still get the benefit of the date that you handed it to the post office. And of course, there's EFS Web. Registered and unregistered users can use EFS Web to file an application. And documents can be faxed to our office. However, and I'll give the fax number at the end of the presentation. However, anything that is required to be in the file that needs to be there for a filing date cannot be faxed to the office. It will not be recognized. It will not be entered into the file. And again, it is recommended that any documents that are required for your filing date of your application are submitted either by priority mail or the EFS Web services, so that in the event that there's a problem with the transmission or problem with the submission for us getting it, we can look into it. It's more easily tracked, and that'll protect your filing a little bit better. Okay. Application data sheet. We're going to get into this a little bit here. The USPTO strongly recommends submitting an application data sheet with the application at the time of filing instead of after filing the application, just because there's a few more extra hoops to go through if you file an ADS after you file your application. So if you file it with your application, then it's a little easier and a little more efficient. An ADS submitted after filing must be properly marked up. Establishment of an applicant after filing is a little more difficult, requires more paperwork, and benefit claims may or may not be submitted timely if the ADS is submitted after filing. When your ADS is submitted upon filing, it must be properly signed, as we discussed in the beginning of the presentation. Signature has got to be properly formatted and by everybody who has authority and needs to sign the application data sheet. The ADS will establish the inventorship of the application, so you'll want to make sure that all that information is accurate. It will establish the applicant when there is applicant information provided on the ADS. It will present domestic and foreign benefit claims if you are claiming benefit of a prior filed application either from the U.S. or from another country. Then the ADS will present that information. However, the ADS will not establish a power of attorney or a microentity status. Even though you can make a notation of that on the ADS, it is not a proper certification. It's not a proper documentation for those two pieces of information. We strongly recommend the submission upon filing of an ADS, or the submission of an ADS period, because it's easier for the applicant to convey all of the information that they need to convey. And it's also more efficient for the office to be able to capture information consistently and accurately. And changing information that's not provided on an ADS upon filing, again, with the markings that are required, that does sometimes provide a stumbling block for applicants and makes it a little more difficult to get through the process. All right. An unsigned ADS or an improperly signed ADS is only treated as a transmittal letter. So it's really low on the list of application information documents. It does not send inventorship for the applicant. It will not establish the benefit or priority claims. Most information will not be captured from that unsigned or improperly signed ADS, and it will be captured from other sources, which may or may not be as accurate as the applicant would like them to be. So it's, you know, if there's no ADS and we have to capture it from another document, it's up to the discretion of the operator to determine that information. Is very subjective, whereas if it's listed on the ADS, it's very clear-cut as to what the information is. Any information that is captured from other sources will become of record in the application and will be a marked up ADS will be required in order to make any changes to that information. Okay. All right. The application application processing, we will capture information as it is provided. We cannot attempt to correct any mistakes that, if it seems as though a spelling error has occurred or transposed letters or names or anything like that, we are not able to interpret the intent of the applicant. We can only capture the information as provided by the applicant. So we will not attempt to correct a transposed or misspelled name, any misspelled words in the title, or any incorrect application numbers in the domestic benefit or priority claims. And as a side note, as you're filing your application, if you're filing it in EFS Web, there's a selection to be made as to what type and the subject matter of your application. And when the applicant selects that during the filing process and selects an incorrect designation, then we also cannot attempt to correct that information either. that that kind of correction would require a petition, and kind of has a few more hoops to go through. So you want to be very careful and very accurate in selecting the application type and the subject matter, as well as making sure that all of your information on your application data sheet is correct. Okay. The inventorship. The inventorship of the application will be the inventor names listed on a properly signed ADS, and suffixes are used to confirm the proper signatures on the oath and other documents. So again, if there's a suffix listed for the name of an inventor, and that inventor is required to sign documents, then we need to see the suffix in the signature in order to confirm that it's the correct person. We wouldn't want John Brown Sr. in the inventorship and John Brown without a suffix in the signature, because we wouldn't know if that was John Brown Sr. or John Brown Jr. Signing the document. Each inventor must provide his or her mailing address, city of residence, and state or country of residence. So this is in the event that there's a problem with the mailing address that is provided for the application. We can have options as to how to get you your correspondence. And we also need the residence, the city, and the state or country. When the ADS sets inventorship, the name provided on the oath or declaration must match the name that's provided on the ADS. That's because both documents require the legal name, and so if the names do not match, then we can't confirm that the correct person signed. And so what would happen is we would use the name set forth in the ADS and require a new oath. If you get a letter that requires a new oath and the correct person signed the oath, but maybe the name is wrong on the ADS, what you'll get is a letter that says something to the effect of, the name on the inventor's oath is not the same as the name on the ADS. This can be corrected. Again, we have no way of knowing which one is correct. So this can be corrected by either correcting the ADS, by submitting a request to correct the inventorship, or it can be corrected by submitting a new inventor's oath if that's the one that has the incorrect name on it. The matching of the names, there are some character substitutions that we need to use for foreign characters, and those are the only exceptions for the match between the two documents. Docket numbers are recommended but not required, but they are recommended for the applicant's identification purposes. We do not put the title on our notices. We only put the title on the filing receipt, and all of our notices are identified by inventor name and docket number. So if you are filing multiple applications, you'll want to identify them by docket number so that you can easily identify which application the notice would go to. Customer numbers. Customer numbers can be used when designating the correspondence address if you have one. If you have a correspondence address customer number, you will have gotten that issued from the Patent and Trademark Office through the EBC, and you would just provide us your customer number to be used for the correspondence address. Only if you're not going to type out your correspondence address, only use a customer number if one has been issued to you. if you put anything besides the PTO issued customer number for your correspondence address, then it's very possible that your correspondence will go to whomever has that number assigned to them, and it may just be directed to the wrong person. So you want to be mindful of that. And on the application data sheet, there is a filing by reference section, and filing by reference is a very specialized process. It should only be used in limited circumstances. And we're going to go into filing by reference a little bit more. Filing by reference is not the same as claiming a domestic benefit or a foreign priority. Filing by reference cannot be corrected or rescinded or deleted once a filing date is granted, because the filing date is granted based on that reference to another application. Filing by reference requires that a prior specification is used. And so if you fill out the filing by reference section on the application data sheet, as well as submitting a specification and claims and drawings for that application, we will disregard the specification and claims and drawings that you've sent in lieu of the reference that you've made on your ADS. A filing by reference will allow you to file an application and obtain a filing date in the event that you don't have a specification ready for this application, but you are planning on using the specification from a prior filed application. You can refer to that prior filed specification until you have your specification ready for this application. And again, only complete the section of the US or of the ADS if you fully understand the reference filing process. You want to fully understand what a filing by reference is and why you would want to use it. If you do not fully understand the process of a filing by reference or the requirements relating to a filing by reference, please do not complete this section. If you have questions about why you would want to or how to use the filing by reference, please contact the office, and someone would be able to help you. If you contact the Patent Legal Administration, someone should be able to give you some guidance there on the filing by reference. But please don't guess that you might use the filing by reference if you are not absolutely sure. Let me go back a little bit. Filing by reference cannot be deleted or removed. It is if there's a mistake and you actually didn't intend to file by reference, then you would need to file a petition, and that can be a little bit of a difficult process as well. So just trying to save a little bit of headaches on that filing by reference. Again, only if you fully understand the filing by reference process would you want to complete that section of the ADS. If you do intend to reference file, then we will rely on the specification and drawings from the referred application. We will give you an application number, a filing date. You must give us the application number, the filing date, and the intellectual property authority of the prior application. So if it was a prior U.S. application, you would want to give us the application number, the filing date, and then tell us it was a U.S. application. Must be made, the reference filing statement must be made upon filing, and it must be in English. You can't submit your application and get a filing date and then decide that you want to reference file, because then it would be too late. The filing date is based on the statement and not on a specification document. Domestic benefit and foreign priority is only captured from the ADS. That's the only way that it can be provided to us. If it's provided on any other document, we would not consider it, we would not enter it, and it would be not acceptable. Benefit claims are captured as provided on the ADS. So we, again, cannot guess at a wrong application number. We cannot guess at a wrong relationship. So we can only capture it as it's provided to us. If there's information missing, we will not attempt to look up that information or try to complete it or correct it. If there's missing information, then we just won't capture that benefit claim or any benefit claims that derive from that incomplete benefit claim. Common problems that we see with the ADS, again, not properly signed, the incorrect people, not enough people, not all of the inventors have signed it, or the formatting is incorrect and it's missing slashes or extra slashes or has incorrect characters. The inventor residence is not completed correctly. We need a city and state or a city and country. And if the state or the country designation is missing, or if it's invalid, meaning we cannot capture it in our systems, then that residence would be considered incomplete and we would not be able to capture it. For example, if you gave us, say your the residence was Alexandria, Virginia, and you gave us Alexandria, but failed to tell us that the state was VA, then we would not be able to capture that information. Also, if you gave us an incorrect, invalid country code or state code, such as if you VR or something like that instead of VA, it's not something that we could capture. Our systems are, they take them from a list, and so we can only select from the listing of the properly designated state codes and country codes. So if anything that you give us is invalid, then we would not be able to capture that also. Domestic benefit claims and foreign benefit claims may be incomplete or correct. That's another thing that we see often, or that they're improperly formatted. Domestic benefit claims must be given from the current application backward in time. So it's chronologically from the most recent to the furthest away. And so if you give us the oldest case first, then we would not be able to capture any of your benefit claims. Domestic benefit claims and foreign priority claims must be presented in a timely manner. We have certain time frames in which this information must be provided. And if it's not, then that requires a petition to add it late, and you may end up with problems with that. Okay. Specification is necessary for a filing date for every type of application, except for when you're filing by reference, and then we use the reference as the specification. Must have a written description of the invention. Must be in English or have an English translation of a foreign language specification. There's a fee that we add for more than 100 pages of specification, claims, drawings, abstracts, and drawings. A specification cannot be faxed into the office because it is necessary for a filing date. And the specification must have a written description of a sufficient written description of the invention so that we are able to tell what the invention is and be able to grant a filing date on it. If your specification simply says this invention is a new way to send a letter, but doesn't tell us how it works or what it does, then there's probably not going to be a filing date granted for your application. It needs to be a sufficient written description of the invention. The specification needs to, again, contain a sufficient disclosure. And if there's no filing date granted, there's no specification of record. So again, you need a specification in order to get a filing date. And when there is a filing date granted and there are problems with your specification, formatting issues, then any corrections to be done need to be relative to the specification that you've already sent in. Okay. Specification has to have certain requirements here. Needs to have either 1.5 or double spacing. Needs to have sufficient clarity so that we can read it and so that we can scan it into our systems and OCR it. It cannot have missing or illegible text or pages. So if you are copying your specification and you leave a sticky note on one of the pages, then that's going to require correction. It needs to have a brief description of the figures. If you have drawings for your application, then it needs to have a brief description of each of those figures. This says landscape orientation. Landscape orientation is not permitted. It does need to be portrait orientation. There cannot be any embedded figures in your specification. Those will all require correction. Application size will be determined by the page count of these application parts, and there is a discount for electronically submitted application documents, and it's reduced. There's a 25% discount. Claims are no longer required for a filing date. They used to be. They are required in order to get to your examiner, and it's recommended that they're submitted upon filing because there is a surcharge for an application that's filed without claims. For a design application, claims are necessary for a filing date. Your claims need to be in English. There's a fee for claims over the standard total that we give you. They must start on a separate page. They can't have, they can't start at the end of your specification on the bottom of that page. And they require the same paper, language, writing margin requirements as the specification. The abstract also has the same requirements as the specification. Must be present and in English, and also needs to start on a separate page. So you can't start that at the end of your specification on the bottom of that page either. Okay, drawings. This does trip a lot of people up. Drawings need to be properly labeled. Remember, there was a brief description of each of your drawing figures in your specification, and so each drawing figure that you show needs to correlate with the figure that's described in your specification. And the labeling needs to be fig or figure, followed by a number or a number and a letter. Can't have anything crazy like this is, schema 1-7-25. It has to be figure 1, figure 1A, figure 1B, etc. They must be line drawings. They must have proper margins. Everything needs to be oriented so that when we hold the piece of paper that the drawing is on, so that we can see the figure, all the labeling needs to be able to be read in that same direction. Needs to have proper clarity. It can't have smudges and erasures and things like that. It can't be shown on a non-white background because that will show up blurry in our scanning. And no extraneous text or captioning. All of the explanations and captioning and things should be in the brief description of the drawings or in your specification. The figures must be labeled in the same manner they are described. The numbering of the figures must be consistent with the numbering in the brief description. And I'll give you a little example here. So in your brief description, if you have figure 1 and figure 2 in your specification, then the figures that you want to show are figure 1 and figure 2. If you have a brief description, something like this, figure 3 is this, and then you have figure 3A, B, C, D described within that following paragraph, you want to make sure that you have the figure 3 labeled with the subparts labeled as well. And this is acceptable. This is also acceptable if you have just the parts of the figures labeled, figure A and figure 3A, B, C, D, and they're all individually labeled. Now, what we don't want to see is figure 3 and then the A, B, C, D, but then we don't have if you look at the figure here, we don't have a figure 3 label. So we're looking for the labels to match the description, and since we don't have a figure 3 label in this example, we would have to reject this this labeling. And the converse here, we don't have a figure 3 described, but we do have it shown in the figure, and so we would also object to that because you have something showing that hasn't been described. All right, and okay, so filing fees. We've got fees are paid according to the entity status established at the time of payment, which means if you assert your small entity status on your ADS, then you can pay your fees in small entity amounts. You must have a micro-entity certification in order to pay the micro-entity fees. If you do not have an assertion or your assertion is faulty in any way, not properly signed or whatever, then you would not be able to be eligible to pay those fees until the certification is proper. You can pay by credit card, you can pay by check or money order, or you can set up a deposit account with the USPTO. The credit card payment, I believe that there's a checkout option at the end of a filing on EFS web, but you can also fax in a credit card payment. We have one of those online, of a form. Let me see. Micro-entity certification must be identified with correct information. All the information given on the micro-entity certification must agree with the information in the file. It can't have a different application number. It can't have a different title listed, that kind of thing, or we would need to reject that certification. And it also must be properly signed. Any fees paid in microentity amounts without a proper microentity certification, we'll just kind of hold those until you either correct the certification or you pay the larger amount of fee, whichever is appropriate. Applicants can only be named on an ADS. The inventor is the applicant unless an applicant is named on the ADS. So if there's no applicant company, then the inventors automatically become the applicant. You don't have to enter that information in the applicant section. Applicants can only be changed, but they cannot be deleted completely. So you want to make sure that that information is accurate when you fill it out. A correction to the applicant name must be shown on a properly marked ADS. change of inventorship, or excuse me, change of applicant after the inventorship is established requires a request under 37 CFR 1.46, which is the rule governing applicant, and requires a corrected ADS. It also requires a statement showing the change of complete change of title. And if you established an applicant and then want to remove the applicant and return applicantship to the inventors, then you would either need a showing of chain of title, showing that that applicant no longer has rights to that application, or you would need to file a petition. And this, I think, just kind of restates all of that. Let me see. An inventor's oath or declaration can be used to set the inventorship if an ADS is not submitted. An inventor's oath or declaration must be submitted for each inventor. Again, if there is an ADS that sets inventorship, then the names must agree. The inventor's oath must be properly signed and must contain the required statements below. Again, if you use one of our forms, then those statements are already on there, and it's much easier on everybody. Substitute statements must be properly completed, and substitute statements are only used when the inventor is deceased or legally incapacitated and cannot sign an oath or declaration, or if there's an inventor that cannot be found, has participated in the invention and then disappeared, ran away from home or whatever, cannot be reached or refuses to sign, maybe there's a dispute or something, then that is required to have a substitute statement also signed by the applicant. Let me see. Okay, this is the fees again. I'm not sure why that's twice. Okay, submission methods for a response to a notice are the same as the submission methods for filing an application, except that responses may be faxed to the USPTO official fax number. And again, if you're not filing by EFS, EFS Web registered users are the only ones that can file a response to a notice or any kind of follow-on documents into an existing application. If you are not a registered user and you attempt to file a follow-on document or a response to a notice, you will end up getting a new application number for those documents, and it will be processed as a new application. Again, we recommend if you're going to mail in your application that you do it with the Priority Mail Express service, so that again, you can get the benefit of that date. Okay. Electronic submissions, if you are a registered user, again, if you are a registered user, you can submit follow-on documents, and when you do that, we strongly recommend using the correct document description for submissions. If you're not sure, you can call the EBC and they should be able to give you some guidance. You can look through all of the document descriptions and find the one that best fits the purpose for your document. Using the correct descriptions will ensure that the correct office is notified of your incoming submission. If you don't use a document code that triggers a message to us, then we would never know that it's there, and we would not be able to process that document timely. Each request should be on a separate document so that you can code them appropriately. If there's one document with two purposes, we may not be able to address both of those purposes simply because we would not realize that they're both on the same document. Okay. Responses that include fee payments or a marked ADS or drawings should not be submitted without being accompanied by a response to formalities notice document. It can be a cover page or a blank document, whatever, but as long as it has a document with that document description, we will get a message. We will be notified that that response is there. Okay. When you get your filing receipt, you want to ensure that you review it carefully to make sure that everything is spelled right, that the information is captured correctly. If it is not, then you're probably going to have an accompanying notice stating that maybe something was unsigned and we didn't capture the information that you wanted us to capture. We will correct typographical errors made by us if you just contact the office and say, you know, my name was spelled correctly on the ADS, but someone captured it incorrectly. Can you fix it? We will do that without a marked up ADS. If the mistake was on the ADS and we captured it correctly as presented to us, then it would need the markings. Incorrect or missing information could cause impacts down the line, could just cause difficulties for you, and we don't want that to happen. So we want to make sure that you review your filing receipt right away so that anything that is not captured as you want it to be can be corrected or addressed. Okay. Alrighty. And again, if there is something that is not captured correctly, then we'll correct it. But if it was captured correctly but presented to us incorrectly, then a properly marked ADS is needed to make those corrections. Corrections to inventorship and the applicant cannot be made after the issue fee is paid. So this is why you want to review your filing receipt right away so that you can get that taken care of before it gets too far down the line to be able to correct. And a delay in correcting a benefit claim could result in the need for petition. It could result in need for additional review by the examiner based on the priority that should or should not have been there. Oh, oops, okay. If you have any questions regarding our notices that we send you from pre-exam, please direct them to the Application Assistance Unit as stated on the notice. I know some inquiries are directed to the operators that review our applications, but our operators are tasked with reviewing the applications, and so they have their work to do, and the Application Assistant Unit is directed to address the applicant inquiries. And any email inquiries that need a detailed response will need to have an email authorization form. And again, that can be found on our website as well. Let me see. And if there's an email inquiry and we are authorized to address it, we will make a copy of that communication and put it in the file. And if there is not an authorization, then the USPTO is not required to respond to that inquiry. Right. And additional resources. I'll just leave that up there for a second.
Okay, Janice, we are near the end of our time here, but we do have quite a bit of questions. So I'm going to read about 3 questions. That's about all we have time for right now. But those of you who did send in questions, we will get you answers to those questions. We do have the emails and we will respond. So Janice, to start, I have my first question, which is, how is the signature of a deceased inventor handled? Is there any obligation to file an application? Oh, sorry, different question. How is the signature of a deceased inventor handled?
Okay, the signature of a deceased inventor. So if the inventor was able to sign before he deceased, then he has a valid inventor's oath in the file. However, by the time the application gets to issue, you would want to submit a substitute statement on behalf of that inventor just to acknowledge the change in status for him. Now, of course, if the inventor deceased before he was able to sign an inventor's oath or declaration, then a substitute statement would need to be signed on his behalf by any one of the other inventors or a legal representative of that inventor.
Great. My next question I have is there any obligation to file an application with a registered practitioner?
There is not an obligation to do so. However, the office strongly recommends that a patent practitioner is used so that, again, some of these common problems are avoided and they can help you navigate the myriad of rules and regulations that we have for the patent process. So it's not required and there's no obligation, but it is strongly recommended.
Okay. If I am the inventor, should I fill out the applicant or inventors and the inventor sections?
If you are the inventor, then fill out the inventor section. The applicant section is mainly for someone who, like, I guess, has rights or some say-so in the patent process, but has not had part in inventing the whatever it is that you've invented. So the inventor and the applicant are basically kind of two different things. If you're the inventor, then fill in the inventor. If you're not an inventor, then and you have some other reason to be involved with the application, then you would be an applicant.
Okay, thank you. And our next question, if I do not correctly identify the inventor on the ADS, how would PTO get that information?
Okay, if you do not correctly identify the inventor on the ADS, we would actually not get that information. We can use other information to kind of confirm the validity of signatures on other documents, but we would not officially capture inventorship unless there is an ADS or an inventor's oath. The ADS would take preference, but if there is no ADS to set inventorship, we would look for an inventor's oath. And if there's no inventor's oath, then inventorship would not be set in that application, and you would receive a notice.
Okay. Next question we have is, I received an EFS login after having an attorney file a patent for me. How can I attach this new EFS so I can view my application?
That I don't know. That is more for our electronic business center, I think, to address because it deals with the actual electronic filing system process. We only review the application documents in OPAP, so that one I would have to defer.
Okay. And the last question we have, if an ADS is rejected for lack of signature of the second inventor and accepted as just an attachment to the application, does it mean that the two inventors may just submit another ADS? Or the inventor should go through the longer process of correcting the ADS?
Okay, so if the ADS is signed only by one of two inventors, then it is not properly signed and would not be recognized for a source of much of our data. So what you would want to do is send in a corrected ADS, and that would require the proper markings. Or if there's no inventor's oath, okay, again, If the ADS is not properly signed, we would look for an inventor's oath. And if there's an inventor's oath and that's properly signed, then we would take the inventorship from there. And then any other corrections would need to be submitted on a corrected ADS, a marked up ADS. If there's no inventor's oath and the ADS is not properly signed, again, we would not establish inventorship, and we would need either a marked up ADS or a properly signed inventor's oath after that to establish inventorship.
Okay. Well, Janice, thank you. That was a great presentation. We do have a lot of questions. We'll be sending those to you as well. At this time, Janice, thank you for your participation, and we'll get you that information for you to answer those questions